Mishcon Academy digital sessions.
Good afternoon, ladies and gentlemen, and members of the Mishcon family, and welcome to this digital session on COVID-19 and the challenges for the real estate industry. My name is Nick Doffman, and I am a partner in the real estate department here at Mishcon. Joining on the panel today are four of my partners: Joanna Lambert from our property litigation team, Richard Gerstein from our construction team, Anita Rivera from our planning team, and Omika Paul from our debt advisory team. So Joanna, we'll start with you first. The current lockdown situation is obviously problematic for both landlords and tenants. Offices and flexible working spaces, bars and pubs, restaurants, retail units have all been forced to close their doors. Could you outline some of the key developments in this arena introduced by the Coronavirus Act 2020 and what avenues may be open to landlords and tenants as they navigate through this uncertainty?
I think it's clear to all of us in the real estate industry by now that the government's priority at the moment is to protect the high street and save jobs, starting with the initial moratorium on forfeiture, which was enacted within 24 hours of it being announced. And this was followed up a couple of weeks later by the announcement, which was made this time last week, of a further moratorium on the presentation of statutory demands on winding up petitions to collect rent when we don't yet have any detail of the changes. There's still no draft legislation, but there's been much fanfare both from government and from, in particular, retailers about this new legislation. And the government has made clear that it's willing to take steps to protect tenants from aggressive landlords. Now, some might say that there's nothing aggressive about taking steps to recover what is contractually due to you. Government has said this specifically in the Coronavirus Act. These steps, this legislation is temporary, and it doesn't waive or in any way alter a tenant's liability to pay rents.
And how is insurance going to assist either landlords or tenants?
We have seen as a team some signs of insured parties being given misleading advice by brokers and insurers as to the extent of their cover, and it's well worth getting an independent view of a particular insurance policy. So it isn't necessarily clauses around disease or notifiable disease or pandemic that are responsive in the present situation. Some of the more promising cover relates to denial of access or loss of attraction or the actions of competent authorities.
We hear a lot about the concepts of frustration and force majeure. And how will they impact on the landlord and tenant relationship?
Force majeure is not going to help at all. Frustration is a more difficult concept. And the English courts have held that in principle, leases can be frustrated. But given all the hundreds of years of English property law that we've got behind us, there is currently no reported case of a lease actually having been frustrated in English law. The important thing to bear in mind, given the current pandemic, is that frustration is a full-time thing. So if a lease is frustrated, it comes to an end forever. It is unlikely to intervene to bring leases to an end, other than perhaps in very unique and exceptional circumstances.
Richard, let's turn to construction, please, and the construction industry. It's inevitable that we see disruption to ongoing projects, construction sites that remain open. What are some of the key considerations? Specifically, what grounds are there for suspension and termination under the JCT form of building contract? And what other advice can you offer in managing those contracts?
The unamended JCT contract has two provisions in it which may be relevant. One is force majeure. The other provision is the exercise by the government of a statutory power. What the Construction Industry Council has done is provide a set of site operating procedures. And these procedures are saying is that if a site does not consistently implement the measures set out by Public Health England, and if an activity can't take place safely, it just shouldn't take place at all. So what about ongoing sites? I touched briefly before about health and safety. And under the JCT, the contractor is obliged to compliance with the CDM regulations. But the principal designer still has responsibilities for health and safety file. What we are seeing happening is discussions taking place between parties to construction contracts as to variation of the terms. And I've seen some parties agreeing to close down the sites on certain terms of liquidated damages clauses. I think you just need to be very careful with these, because there is an implication for all the other parties to the project. If you give instruction to close the site, then you're liable not only to an extension of time, but also to loss and expense. An interesting point's come up with one of our clients recently. They asked me, as an employer, they were liable if any of the contractors' workforce caught COVID-19 when they were actually on the site. JCT provides that the contractor should indemnify an employer against such liability, and also provide insurance for that.
Anita, let's talk planning. We've heard from Richard about delays and uncertainty within the construction process. How is the planning regime adapting to the current situation? And should the government intervene to encourage development in the hope of stimulating the economy?
I think it's really fair to say that the planning regime is going to play a crucial role in helping to kickstart the economic recovery following this lockdown. So what changes in the planning regime have actually been implemented so far? Well, the first and fairly immediate response has been to create new permitted development rights. Now, these new rights allow a temporary change of use from pubs, restaurants, and cafes to operate as a food takeaway. The rights cease to apply either on the 23rd of March 2021 or when the temporary use ends, whichever is the earlier. The other major development arising is the creation of virtual planning committees so that local planning authorities can still make decisions. The regulations have come into force, which now allow that councils can take planning decisions using virtual committees by video conferencing software, things like Zoom and Microsoft, everything that we're now really used to. A lot of councils across the UK have really embraced this. In London in particular, there are a lot, I'd say half of London authorities have either already had a virtual planning committee or have already scheduled one. So now I'm going to talk about what the real concerns are facing the industry and what might be on the horizon to address them. Planning appeals can still be lodged with the planning inspectorate, which we call PINs. The problem is that because there's no physical site visits, there are no hearings and no inquiries currently being held. They will be trialing their first digital hearings. I would suspect that it's going to be probably on a single matter, uncontroversial issue. They're really hopeful of rolling out over the next 3 to 6 months so it's fully up and running. Now, we understand that the government is still currently considering to implement automatic extension of time for planning consent of up to a year. But until those provisions are enacted, the only course of action available is to preserve your planning consent by way of lawfully implementing it before it expires. Another big issue facing landowners, developers, those with planning consents is the community infrastructure levy. So we all know that the SIL regulations are notoriously inflexible, and they do not include exceptional circumstances that deal with a lockdown event like COVID-19. There's no postponement of a SIL liability, you must pay. So for developers, this creates a real catch-22 situation. Do you preserve your planning consent by implementing it, and thus incur SIL liability, or do you let the consent fall away?
Is COVID-19 the final nail in the coffin of the high street?
Well, I think it's fair to say that the high street was in dire straits even before COVID-19. One of the things that the government put forward was to widen the scope of Class A and make it more flexible. The use class order is incredibly restrictive about what uses are allowed where, and opening that up has to happen sooner rather than later. We have to think creatively, openly, more broadly.
Omega, over to you finally. Understandably, there's been a nervousness in the real estate finance market. So can you tell us a little bit about trends that you're seeing in terms of both existing financing, new lending, and are there particular assets that we can expect to see fare better than others?
So we're definitely still seeing deals getting done, and there are certainly lenders that have appetite to lend and are still very much open for business in the market. But that said, the real estate finance market now is markedly different from that pre-COVID. If I start with existing lending, as you might expect, lenders with legacy books have rightly been focusing on running through their books, assessing what losses they may have. Anecdotally, the feedback that I've had from lenders is that they appreciate that the pandemic is not just, if you like, a borrower or equity risk, but is something that there will be some element of risk sharing across the piece, including lenders taking potentially some element of pain. Lenders have their own regulatory requirements to meet. They've got their own risk parameters and potentially their own capital constraints. If we turn now to new lending, for the most part, lenders seem to be honouring commitments that they've made in principle, with the potential exception of retail and hospitality transactions. We have seen some cases where lenders have pulled out even where deals are already in documentation stage. But on the flip side, we've seen other lenders step into the breach and the shoes of that previous lender and take over that transaction. And the feedback that we're getting from some of our contacts is that their inquiries on an average basis are maybe double what they would be, say, this time last year. Some of the lenders who are really more relationship focused and see this as a good opportunity to displace perhaps more traditional lenders, we're certainly seeing a pullback in leverage appetite. And finally, just to touch on your question, Nick, about asset classes, it's probably no surprise to anybody that hospitality and retail assets are particularly challenging to finance at the moment. But we are actually seeing some lenders who are able to adopt a slightly more innovative approach. So maybe you're looking to finance a hotel and taking security over another asset within the wider portfolio.
Do you think that's an integral part of recovery of the economy?
Once there's an understanding of what values may look like going forward, then we'll certainly see an opening up of the taps in terms of finance that may be available.
I've got here, probably for you, Joanna, we are a retailer and want to put a clause in new leases that rent is not payable if our turnover goes less than X to cover future pandemics. Do you think this will wash?
I think that ultimately the market is going to have to find a new equilibrium. Now that we can foresee the future, the market is going to have to decide how it wants to adapt and deal with a future pandemic and shutdown. We've got two, diametrically opposed positions from landlords and tenants, and each will want to gain some measure of protection. And I suspect it will be one of those things where there's a meeting in the middle.
Richard, one for you. Social distancing has kept us at home with only essential services open, hospitals, food, retailers. But at some point, most of us will return to the workplace. Given the environmental benefits, such as improved air quality that we have seen as a side effect of the lockdown, are there ways we can change the design of our built environment to make it healthier?
I think one of the really interesting things that we've seen over the last few months, really, and definitely been a reasonable take up in the UK, is the sort of the development of digital fabrication. Product being built and buildings being built essentially off-site digitally and coming to site and just being effectively screwed together when they're there. And I think that's going to make a big difference. I think that's going to make a big difference to the way in which building sites operate. Although conversely, it's also going to mean quite a lot of road traffic with things being shipped to site. And that's going to have an adverse effect, obviously, on the environment.
What, in your view, is the biggest challenge facing the real estate industry in the next 6 months?
Unpaid rent. Tenants who are going to struggle to pay it, landlords who are going to struggle to collect it.
Yeah, I mean, essentially it's the same. It's cash flow. It's cash flow within the construction industry and making sure that they're in place to actually do the work that they promised to do.
I think I touched on this before. I think the biggest challenge is valuations, both in terms of market information, trading information, but also practicalities of getting on site, for example.
I think it's going to be financial valuation of schemes to see whether they actually balance the books and make it actually desirable to deliver new schemes.
For our latest guidance and online content related to COVID-19, you can visit our hub at mishcon.com/COVID-19. And if you have any follow-up questions, please feel free to contact us on our dedicated email address, coronavirus@mishcon.com. That just leaves me to say thank you very much. I wish you all a good afternoon and obviously continued good health and well-being. Goodbye.
The Mishcon Academy Digital Sessions. To access advice for businesses that is regularly updated, please visit mishcon.com.